55 young footballers which are going to attend a training camp in Italy for 1 year. Offer.
Seems pretty good. I shall agree to it. Acceptance.
So you're alright with the price, which is £824,000 or 1.6 million Singapore dollars. Consideration.
Of course. By signing this thing, that means I totally agree with what is stated on this contract. I think we have a deal here. Intentions to create legal relations.
Okay, let's pause right here. What you have witnessed right there is the formation of a contract between the Genova International School of Soccer and the Sembawang Soccer Academy. There are two standard forms of contract, the first being simple contracts, which are made orally or in writing. The second being special contracts. These contracts are formed for the sale of special things, such as land, property, and shares. There are four essential elements of a contract. The first being offer. An offer is an expression made by one party, in writing, orally, or by conduct, communicating his willingness to enter into a contract. As we have just seen, our Shichao has offered Genova International School of Soccer to send 55 of their players over to Italy to attend a training camp over the period of a year. The second element of a contract is acceptance. Once there is an acceptance of an offer, there is a legally binding contract, assuming there is intention to create legal relations. As what we have seen just now, our Daniel Ho has agreed to the offer by Shichao. Over here, acceptance is when he says that he agreed and when the contract has been signed. The third important element of a contract is consideration. Consideration is essential for all contracts, except those that are under seal. In simple terms, consideration is the price or compensation for the promise given by one party to the other. As we have seen earlier, the £824,000 which Shichao offered is the consideration. The consideration right here is an executory consideration, since there is an act to be performed at a future date. The fourth element that must be present in a contract is the intention to create legal relations. If the intention to create legal relations is not present, then there is no legally binding obligation which can be enforced in court. In the case of commercial agreements, which is this one, there is a general presumption that there is the necessary intention to create legal relations. And therefore, with all those elements present, a contract is formed. Let us get back to the video and watch some really epic acting.
Hello? Hey boss! What's up?
Okay Faisal, I'm going to send you to Italy for training camp. You'll be around 3 months.
Serious?
By the way, you are one out of the 25 lucky few that we selected.
Of all people, you select me sir. Apa sial? Thank you boss, you know I love you so much. Aku love you, no. Aku sayang you boss. Terima kasih ya. Come, I buy you lunch another day ya. Okay, right now, right? Then I just pack my stuff. Then we going to the we go Italy. When? So soon. Okay, steady. I go my I pack already. Thank you boss. You know I very grateful, right? Okay, see you. Bye.
Napola quando sola t'abbandona, lo cielo si fa tutto rosa color d'oro a campana do Carmo.
What? We haven't received the first payment from Sembawang Soccer Academy? You know what? I think I can't tired of this. Let's kick the boys out. Just send them home, man. Right. Talk to you later. Okay, bye.
Round one, fight!
Apa sial? I call my boss already. Hello boss. Apa sial? You bring me Italy already, right? Then after that, he tell me the contract cancel already. Eh, apa? The contract cancel. Then I down here Italy. They keep me, I got no room, no. Not very serious, you know. Boss, abang work so hard already, right? Then aku come here, then you tell me that the contract problem. And I don't know what to do. So I do now. What's this? I cannot. They keep me out of my room. They dump all my belongings, all my valuable. They bring it outside. Then I don't know what to do really, so.
嬲你哋澳洲為 wrong accent. Hello, ladies.
Hello, ladies. Look at your man. Now back to me. Now back at your man. Now back to me. Sadly, he isn't me.
I wasn't trying to copy him at all. So what happened just now was that Brandon, the Malay soccer player, was getting kicked out of his hotel in Italy due to the fact that the Sembawang Soccer Academy has failed to pay the first payment of £179,500. This results in a breach of contract, or more specifically, an actual breach of condition. Let me break it down for you! A breach occurs when a party fails to perform his/her obligations under the contract. An actual breach is when a party fails to perform the obligation when the time arrives. An anticipatory breach is when the promiser has expressed his intention not to perform before the time arrives. Next, we have to understand the severity of the obligation by looking at what are terms. Terms are promises and undertakings given by one party to the contract to the other party, which if not met can sue for breach of contract. The next step is to identify whether this term is a warranty or a condition. Conditions are crucial terms that are fundamental to the contract. They are statement of facts that go to the root of the contract, whereas warranties are less important terms and comprise the subsidiary obligations of the party to the contract.
Yes! Oh my god!
The remedies available to an innocent party for a breach of contract fall under the common law of damages, and for equitable remedies, injunction, specific performance, and quantum merit. And in this case, we will be focusing on damages. Damages refers to the monetary compensation payable by the defaulting party to the injured party or the innocent party whenever a breach occurs. In the law of contract, damages are intended to place the plaintiff back in the same position he was if the contract was properly performed. Let us now watch an animation featuring the relevant case, Hochster versus De La Tour. In that case, the defendant agreed to engage the plaintiff as a courier for European travel. Before the defendant could perform his actions, he told the plaintiff that he was no longer in need of his services, and therefore the plaintiff sued for breach of contract and was awarded damages by the court. In the case of Genova International School of Soccer versus Sembawang Soccer Academy, an actual breach of condition occurred since the Sembawang Soccer Academy has failed to perform a major obligation that is fundamental to the contract when the time had arrived. The obligation being the £179,500. Since there was a breach of contract, the Genova International School of Soccer can sue Sembawang Soccer Academy for damages. Let's get back to the video.
Mr. Ho, this is Brennan Chu, lawyer for the GISS, and I understand that my client has not received a first payment as agreed on in the contract for £179,500, which is the equivalent of 359,500 Singapore dollars. And for this, we have decided that despite giving a 10-day extension to for your side to fulfill your commitment, and despite it not being done, we have decided that in view of this, you are not in the capacity to negotiate with us on this agreement to the contract anymore, and we will be taking this matter to court to seek compensation for $824,000 pounds, which is the equivalent of 1.6 million Singapore dollars for the damages or inconveniences being caused to our firm or to my client. And for this, we would be discussing this further in court. I'll see you there. Goodbye.
Well, did you know that there are a total of 9 courts in Singapore? Well, of course you do. All of you are business law students. The Supreme Court consists of the Court of Appeal and the High Court. The Court of Appeal is the highest court in Singapore and can hear both criminal and civil cases on appeal from the High Court. Which makes me wonder, why isn't the Court of Appeal called the High Court? The High Court also hears criminal cases which are punishable by death or imprisonment exceeding 10 years. The lower courts are collectively called the subordinate courts, which consist of the Magistrates Court, the District Court, the Juvenile Court, the Family Court, Coroner's Court, and the Small Claims Tribunal. On top of all those, let us not forget the Sharia Court. The monetary limit for the District Court on matters like contract and tort is strictly $250,000. For criminal jurisdiction, the court can try all offences for which the maximum term of imprisonment does not exceed 10 years, or punishable only by a fine. Now, the monetary limit for the Magistrates Court is strictly $60,000. For criminal jurisdiction, the court can try all offences for which the maximum term of imprisonment does not exceed 3 years, or punishable by a fine only. The Juvenile Court was created for the purpose of dealing with offences committed by children of 14 years and below, or young persons of 16 years and below. The concern for the Juvenile Court is more of reform and rehabilitation instead of punishment. The function of the Coroner's Court is to ascertain the cause and circumstances of death whereby there is reason to believe the suspect has died in a sudden or unnatural manner, by violence, or where the cause of death is unknown. The coroner does not conduct a trial, but merely an inquiry into the cause of death. The Small Claims Tribunal was intended to provide inexpensive and speedy avenue of redress for consumer grievance. It can hear disputes arising from contract of sale of goods or provision of sales whereby the claim does not exceed $10,000. In fact, if both parties consent in writing, it can hear claims of up to $20,000. The Family Court hears divorce cases and other related matters such as the custody of children and the division of matrimonial assets. It also hears cases of adoption, maintenance, and personal protection orders. Last but not least is the Sharia Court. The Sharia Court is a separate court for the Muslims. It hears and settles disputes relating to divorce, maintenance, custody of children, and inheritance among the Muslims. Let us get back to the video to watch the finale of the case.
During the trial, it took just 10 minutes for the court to rule in favor of the Italian football school by default judgment, as there was no representative for the Sembawang Soccer Academy. And therefore, the Sembawang Soccer Academy has been ordered by the High Court to pay 1.2 million Singapore dollars plus interest to the Genova International School of Soccer.
Wah, sini, wah, sweet.